Now, in a landmark verdict, the Supreme Court has cracked the whip on the withdrawal of open offers by the corporate houses. Ashwin Mohan joins us with more details on this ruling. Ashwin, good to have you on the show. Now, what is the top court's decision? And of course, it will have far-reaching impact on almost all the companies. But which are the immediate companies to get impacted?
That's right, Nisha. In fact, this is a massive judgment that has come in from the Supreme Court. It essentially lays down the law of the land when it comes to withdrawal of open offers by India Inc. It is a judgment that is going to have a ripple effect on several other open offer cases involving other companies like Arvind Mills, like companies like AP Paper Mills, Golden Tobacco, Khaitan Electrical. So clearly, this is a decision that is going to have widespread ramifications. The law of the land has been laid down as follows. If you're a company that has announced an open offer, you cannot withdraw it on the grounds that it has suddenly become commercially unviable or that it is no longer economic. So that is the main ground. You cannot go back on your open offer obligations if you suddenly find out that the market conditions don't suit you or that it has become commercially unviable. That's the biggest takeaway from the Supreme Court judgment. The second judgment is, of course, also an area which has been tightened as far as withdrawal of open offer is concerned. And that area is that companies can no longer cite any delay that has been caused by market regulator Sebi in terms of responding to open offer applications and say that because of the delay, we are going to go ahead with the withdrawal. That's the second takeaway. And the third takeaway, Nisha, is clearly that the Supreme Court has also laid down the rule of the land, saying that there is no distinction between a voluntary open offer and a triggered mandatory open offer. In some cases, there were some companies which had gone ahead and said that because we have voluntarily made an open offer, we should get some benefit and hence we should get some relaxation. So on all these three grounds, the Supreme Court has in fact ruled in favor of Sebi. It was a case involving an open offer that was voluntarily made by Akshaya Infra in the case of Marg Limited, and Sebi had in fact lost the case at the Securities Appellate Tribunal, and Sebi had gone ahead and filed an SLP at the Supreme Court. So this is therefore the decision coming in from the Supreme Court as far as withdrawal of open offers is concerned. Clearly the Supreme Court siding in fact with Sebi, because Sebi felt that such permission of withdrawal of open offers could set a wrong precedent. It could in fact be detrimental to the interest of the shareholders. So clearly a path-breaking decision coming in, Nisha, from the top court of the land.